We have a powerful legal brief in support of the Second Amendment submitted by the California Rifle and Pistol Association, the Second Amendment Foundation, as well as the Second Amendment Law Center out of Nevada. Powerful brief submitted to the United States Court of Appeals for the Ninth Circuit talking about machine guns and whether or not they're protected arms. Let's break this down when we come back in one moment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many Second Amendment related books, including Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, so we're going to cover a major legal brief submitted, an excellent legal brief today, submitted by two law firms, the law firm of Michelle & Associates and Donald Kilmer, in the United States Court of Appeals for the Ninth Circuit, arising out of a case involving machine guns, allegations of an alleged illegal transfer or an attempt to illegally transfer a machine gun out of the state of Oregon. Specifically, the lower court found after a jury trial that an individual, Daniel Kitson, 61 years of age, basically tried to transfer an alleged illegal machine gun, specifically, according to the allegations, I hope I got this right, a Russian-style machine gun that, according to the ATF, for what that's worth, could shoot upwards of 900 rounds a minute. Count me as skeptical, but nevertheless, I'll put a link to the ATF and Department of Justice press release down below, and you can check it out for yourself. Anyway, there was a litigation as to whether or not the law under which Daniel Kitson was charged was constitutional. It was in front of a judge who's a terrible anti-gun judge, utterly useless on the Second Amendment. You may remember her, the Honorable Karen Immergut. She's the one that upheld Oregon's law under the Second Amendment in a terribly useless and wrong opinion. We've covered this before. So there is not going to be any relief in front of Judge Immergut when it comes to anything touching on guns or the Second Amendment. That was just a waste of time. No shock there. With that said, we've talked about this on this channel. I don't think we have 5 votes. I do not think we have 5 votes to say that machine guns are protected by the Second Amendment right now on the Supreme Court. And if we do, we're not going to be able to get that kind of a ruling until we first and foremost get certain necessary rulings ahead of time. Specifically, we need to win, in my opinion, that AR-15s are protected firearms under the Second Amendment. They clearly are. That is undeniably the right answer, but we need the Supreme Court to say it to spank these lower courts into submission because they're not behaving yet again. And of course, I also think we need to deal with magazines holding more than 10 rounds as protected arms, and that anything that either bans AR-15s, semi-automatic rifles, gas-powered rifles, and the like, or magazines that hold more than 10 rounds, let's say, we have to make that undeniably clear by the U.S. Supreme Court that bans on those kinds of arms are not allowed under the Second Amendment before we can even have a conversation about machine guns. But I think in the real world right now, today, in May of 2024, we cannot get 5 votes to say the machine guns are protected by the Second Amendment. With that said, though, that's not to say that the argument about machine guns cannot be analyzed properly under the Second Amendment. And that is exactly what this brief by the Michelle & Associates law firm and Donald Kilmer is arguing here by virtue of saying that Judge Immergut, in upholding this conviction by the jury of the allegedly illegal transfer of a machine gun, that she did not apply the proper methodology under Heller and Bruin, which, as we've talked about before, when you're dealing with an arms ban case, really Heller is the guiding light here. Bruin just reaffirms Heller, and Heller sets forth the constitutional test for how you handle an arms ban case, and that includes, yes, indeed, whether or not machine guns or automatic weapons can be banned under the Second Amendment. And again, you know the methodology. You start with the text of the Second Amendment, and this is where Judge Immergut apparently went awry. You remember the text of the Second Amendment reads, "The right of the people to keep and bear arms, shall not be infringed." So when you're dealing with whether or not machine guns are protected arms under the Second Amendment, you have to focus on the word arms in the text of the Second Amendment. And as you know, the Supreme Court in the Heller decision in 2008 defined arms extremely broadly, and they said that the 18th century definition of arms in the 1700s when the Second Amendment was adopted in 1791, the definition of arm then is the same definition of arm or arms today in the 21st century, which is basically anything that can be used offensively or defensively to attack or defend oneself, which obviously includes firearms. And yes, indeed, that would, at the textual level, include machine guns. Now, Judge Immergut actually found that machine guns are not protected arms under the text of the Second Amendment. That is clearly wrong. Machine guns are clearly arms under the text of the Second Amendment, because the machine gun can obviously be used offensively or defensively, so it's clearly an arm textually. And once an arm, in the context of an arms ban case, is covered or is implicated by the text of the Second Amendment, you know what happens. The burden shifts to the government to show that as a matter of long-standing, continuous historical analog laws, going back to the founding, the particular gun ban or gun they're trying to ban, whatever it is essentially dangerous and unusual for the purposes of an arms ban case. And here's the key. What Judge Immergut did here was basically just said that the plaintiff, in this case the criminal defendant asserting Second Amendment rights, in this case of United States versus Daniel Kitson, Mr. Kitson is the one that was convicted of the crime, of course, of seeking to illegally transfer a machine gun, and Mr. Kitson was convicted, so he is essentially the proponent of the Second Amendment here. I should note that the brief submitted by the Michelle and Associates group, as well as Donald Kilmer, is an amicus brief in support, not necessarily of the ruling involving Judge Immergut and or the defendant here, but basically saying that they're not supporting either the government nor are they supporting the defendant here. What they're simply saying is the Ninth Circuit Court of Appeals needs to at least analyze the Second Amendment question presented in this case of Kitson correctly, because the lower court Judge Karen Immergut, who absolutely is terrible on the Second Amendment, cannot, doesn't even try to apply it correctly or follow Supreme Court precedent. Just a terrible judge on that front. No debate about that in my view. Nevertheless, the lawyers here are arguing that you at least have to do the analysis of Heller and Bruin correctly. Whether you think machine guns are dangerous or unusual is a secondary question. So they do an excellent job in this brief laying out the proper methodology under Heller. They explain it's text first. They explain that machine guns are obviously arms because they're a type of firearm. Firearms are arms. Clearly no dispute. The burden thus shifts to the government. And because the Heller court has already done the historical analogical spade work for what types of arms can be banned historically in the United States, and pointing out that Heller said that only conceivably weapons that are dangerous and unusual, that's conjunctive, both dangerous and unusual can be banned. And they say that the burden, because that dangerous and unusual standard arises at the historical level, and this is very important to understand, we've talked about this before, because the dangerous and unusual test occurs at the historical level of the text first burden shifting historical analog work level, the burden of proof is on the government to demonstrate, in this case, that fully automatic weapons, machine guns, are dangerous and unusual, as that is defined by the U.S. Supreme Court. And basically what this amicus brief, which does a very good job, says is that is really not going to be successful. The first argument they make is they say on page 16 of this brief, and I'll put a link to it down below, that there are 700,000 registered machine guns in circulation, 700,000 machine guns in circulation, and thus arguably they are not dangerous and unusual. In my opinion, this is not accurate and it's not helpful to the Second Amendment cause. We've covered this issue before. Machine guns are not going to be protected by the Supreme Court. We're not going to be able to win the machine gun issue, in my view, with the current composition of the Supreme Court. If you swap out Justice Sotomayor or some other, maybe Justice Roberts, with another more aggressive conservative originalist than them, you might be able to get to protecting machine guns. But right now, with the Roberts court in place, you're not going to be able to do that. So the 700,000 registered machine gun figure is correct, but not really. And what I mean by that, we've talked about this before, the 700,000 registered machine guns in the United States today includes at least 3 buckets of materials, or items, I should say. The first one, and this is the most important one, it's really the correct number for privately owned machine guns in the United States is 175,000 machine guns in private hands. They were in private hands in 1986 when the Hughes Amendment that says you can no longer buy or make new machine guns for the civilian market went into effect. So the proper number is 175,000 machine guns is in circulation in private hands. That is the apples to apples number. The reason why you get to the 700,000 figure is not really an apples to apples situation. You go from 175,000 machine guns in civilian ownership hands as of the 1986 Hughes Amendment. You get up to 700,000 registered machine guns because you then add on all the machine guns, all the automatic weapons that are in the possession that also have to be registered under the National Firearms Act. They're in the possession of local and state law enforcement agencies and or by FFLs, gun companies, gun manufacturers that possess machine guns because they're making them for the military or designing them or whatever they're doing. But the point is they're allowed to have them and they can register them. So the 700,000 figure is not really correct. The number of these machine guns that are in civilian hands is 175,000 according to the United States Court of Appeals for the Fifth Circuit in a case called Hollis versus Lynch. Hollis versus Lynch, citing to information that was turned over in that litigation by the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, and it's 175,000 is the proper number, which is a good number for us because, as you know, in Caetano, the concurrence by Justice Alito that said effectively stun guns are protected arms. The number of stun guns that had been purchased as of 2016, when the Caetano case was decided, was 200,000. Notice how the 175,000 registered machine guns in civilian hands is below that 200,000 figure in Caetano involving stun guns, but AR-15s are way above that. I'm not sure that's a coincidence. I think that is really where the Supreme Court is thinking that machine guns are not going to be protected. There's only 175,000 of them out there in civilian hands. 200,000 is really the floor at which you get protection. Anything above that is protected. Anything below that is not in common use and may not necessarily be protected, including machine guns. I think that is not I think that was not a coincidence the way that concurrence was written by Justice Alito in 2016. So again, I think that while they're saying 700,000 registered machine guns in circulation, I think the proper number to consider whether or not machine guns are protected by civilian use in America is 175. The second point here, I think, is a very clever argument in this amicus brief, and that is that they point out that there were 520,000 bump stocks in circulation when they were essentially banned in 2018, 2019 by the Trump administration, ATF. We understand, we've talked about that issue before, the strategic decision to ban the bump stocks using the ATF to make sure Congress did not redefine machine gun in a way that would be very bad for the Second Amendment community. You can debate the strategy called by Donald Trump and his office, but that was the decision they made, and I at least understand the rationale there. Nevertheless, there's 520,000 bump stocks, and this is a very creative argument. What these lawyers are saying in this amicus brief is, if the government's arguments to the U.S. Supreme Court in Cargill is correct, i.e. that bump stocks can be banned because they are machine guns, well, then the lawyers in this amicus brief are making a powerful argument that says that bump stocks, by virtue of being machine guns, means that the number of machine guns in the United States far exceeds the 200,000 number talked about by the concurrence by Justice Alito and Caetano. And thus, if the ATF's argument that bump stocks give rise to a greater number of machine guns in the United States, it means they are not dangerous and unusual because they're not unusual because they're in common use for lawful purposes. A very creative argument here. Again, I don't think it will be accepted, but I think that the Ninth Circuit and ultimately the Supreme Court might look at that argument and use that as a way to, again, protect AR-15s and semi-automatic rifles on the one hand, but continue to keep machine guns as unprotected because, again, I don't think we can simply get to 5 votes right now. Remember, you turned to this channel not for rainbows and unicorns and for me just to scream out the word shall not be infringed and quote the Declaration of Independence to you. You turn into this channel so I can tell you the way I really think it is in the real world, which is not perfect, but But that's what, I just don't think we can get to 5 votes. If I were on the Supreme Court, I think you know how I would rule, but I'm not on the Supreme Court, so my personal opinion, what I would like to happen, is really not relevant to what I say to you as to what I think is possible with the current composition of the Supreme Court. All right, folks, well, there you have it. Hope you learned something here today at the 4 Boxes Diner. Make sure you follow me on X at 4 Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.